the judge has to make a determination. And if the judge determines that this individual is incapacitated, then the judge eventually will sign what's called a judgment of incapacity. This is a form document. You can find it right on the court website. And it covers quite a few things. First of all, it specifies the type of guardianship. So depending on the nature of the person's illness or condition, that individual may have some capacity to make certain decisions for themselves, but maybe they lack capacity to make important decisions when it comes to other matters. In that instance, the court can be very specific about what decisions the incapacitated person is allowed, what decisions they are allowed to continue to make for themselves, and then what decisions would be made by their guardian. So a guardianship is a very serious process because you really are stripping rights away from somebody. You are stripping away their right to make decisions in all aspects of life, whether it be getting married or voting or simple things such as signing legal contracts. So the court has to make sure that the proper evidence has been presented before they make a decision to determine somebody incapacitated. So they do always, the court always, judges always want to try to give an individual as much, the ability to retain as much freedom to make their own decisions if they have the ability to do that. And again, that's not for me to determine, and it's really not for the judge to determine. It's really just a matter of what the evidence says. So that's why it's so important that we rely on medical professionals to thoroughly examine a person. And they do usually very, very thorough reports that are submitted to the court regarding the person's diagnosis and how it affects them, and how if they can make certain decisions or can't make certain decisions. All of that is covered in the physician's or psychologist's reports, and the judge will consider all of that when making decisions. In addition, in the judgment of incapacity, if you have two people serving as co-guardian, if you have one person serving as guardian, if you have someone serving as guardian of the person and guardian of the estate, which is their property, all of that would be detailed and outlined in the judgment.